evening, friends. This is part 11 of our series of videos on UCP DC. In this session we shall discuss Article 38 and 39. Article 38 talks about transfer of a credit and Article 39 talks about assignment of proceeds under a credit. These are the last two articles under UCP DC. We have total 15 parts of videos, 15 small videos on UCP DC. This is part 11, but here we will be discussing Article 38 and 39. Article 38, Transferable Credits. A bank is under no obligation to transfer a credit. An issuing bank may request a nominated bank to transfer a credit, but the nominated bank is under no obligation to transfer a credit, except to the extent in the manner expressly consented to by them. The nominated bank for transferring may suggest their own terms and conditions for transfer, and if the beneficiary first bene is willing to abide by those requirements, then they may effect the transfer. So the bank is under no obligation to transfer a credit except to the extent and in the manner expressly consented. So the transferring banks to consent to do a particular thing in a particular fashion, and what they will do and how they will do and when they will do, and the first bene should be willing and agreeable to it, only then transfer will happen. So what is a transferable credit? When you say bank is under no obligation to transfer the credit, what is a transferable credit? A credit that specifically states it is transferable is a transferable credit. Such a credit can be made available in whole or in part to another beneficiary. Another beneficiary means second beneficiary, at the request of the beneficiary. The beneficiary means the first beneficiary. In a credit, an issuing bank undertakes to honor an irrevocable definite undertaking to honor if the terms and conditions are met and stipulated documents are presented by the beneficiary. So the credit is addressed to beneficiary by the issuing bank. Now if the credit says it is transferable, then a nominated bank may transfer the credit. By what do we mean by transfer the credit? Make the credit available to the second beneficiary. The credit is presently available to first beneficiary, when we make the credit available to second beneficiary by a transferring bank. This making it available may be for the full or only for a part, and if it is done at the request of the first beneficiary, it is a transferable credit. The transferring bank is a bank nominated by the issuing bank that transfers, or if it is available with any bank, then it should be specifically authorized by the issuing bank to transfer. Transfer can be effected only by the bank nominated by the credit, or a bank specifically nominated for effecting transfer. If the credit is available with any bank cannot transfer the credit. There should be a specific nomination for transfer, or else there should be a specific nominated bank for honor or negotiation under the credit. Only such bank can effect a transfer, and such bank is called transferring bank if and when they expressly consent to transfer the credit. What is a transfer credit? A credit made available by a transferring bank to second beneficiary at the request of first beneficiary. All charges such as commission, fees, cost, whatever it is, all charges for the transfer, all expenses of the transferring bank will have to be met by the first beneficiary unless otherwise agreed. So this is what we mean by in the manner expressly consented to. Now if the transferring bank says you may not pay the charges to the first beneficiary, then this particular clause will not be applicable. The credit may be transferred in part to more than one second beneficiary. We have said that a credit may be made available in whole or in part to a second beneficiary. So if it is made in part to a second beneficiary, then another part can be made available to another second beneficiary. It could not be called as a third beneficiary, it is called another second beneficiary. First beneficiary is a party in whose favor the credit has been issued. Second beneficiary is a party in whose favor the credit has been transferred in part or in whole. When it is transferred in part, another part can be transferred to another second beneficiary, but it is not a third beneficiary. This another second beneficiary will come into picture if the credit allows drawings or shipment by partial shipments or partial drawings. Credit cannot be transferred at the request of second bene to any third bene. Credit cannot be transferred at the request of second beneficiary to any subsequent beneficiary. First beneficiary is not considered as subsequent beneficiary. Why it is explicitly mentioned here? It means the second bene may request the credit to be transferred back to first bene, and such a transfer back is not prohibited because they are not subsequent bene. Second bene is requesting, but it is not a subsequent bene, it is only going back to first bene. The transfer must indicate if and under what conditions amendments will be advised to the second bene. The application for transfer should say whether the transferring bank can pass on the amendments to the second beneficiary. If it says it is conditional, under what conditions can the amendments be passed on? If the amount is going up, if the amount is coming down, if the expiry date is extended, if the expiry date is curtailed, under what conditions the amendments can be passed on to the second beneficiary directly by the transferring bank without referring to applicant. If it is referring to applicant, then applicant will decide and give a fresh request which is called amendment to transfer, because you have already made a request for transfer, application for transfer. Now you are making amendment to the application for transfer, and then that will be passed down to the second bene by the transferring bank. If a credit is transferred to more than one second beneficiary, if you have a different separate second beneficiaries, more than one, rejection of an amendment by one of the second beneficiary does not invalidate the acceptance by another second beneficiaries. Suppose it is shipment of garments and you have had men's full sleeve shirt size 32, and now you are amending saying it is not size 32, it is size 31, or you are saying it is amending saying it is not just a full sleeve shirt, it is black full sleeve shirt. Then one of the second beneficiary may say, I am refusing the amendment. Why? Because they will not be able to supply black full sleeve shirt, they will supply any other color. So they will say they will not accept the amendment, and they will make a shipment, and they will have to be paid, because the credit was earlier allowing such a situation, and they are beneficiaries of such a credit. The transferred credit must accurately reflect the terms and conditions of the credit received, and then the amount, quantity, unit price, expiry date, period of shipment, percentage for which insurance cover is required. These things can undergo some change. Why? When you say credit can be made available in part or in full, it means the amount can be curtailed, can be reduced. The unit price can be changed. The first bene would have got an order for $10 per shirt, and then you may be transferring it to a second beneficiary saying $8 per shirt. You can have an expiry date brought forward, so that if the credit is normally expiring on 31st of March of a particular year, you can say now it will expire on 15th of March for the second beneficiary, so that he will be forced to submit the documents prior to that. Period of shipment can also be curtailed. If the credit allows shipment up to 31st December, you can force the second beneficiary to ship before 15th December. Percentage for which insurance cover is required, this will be increased. For example, if the credit is for $100, the insurance cover will be for $110 normally. Now when you transfer, you will transfer only $80, but you need insurance for $110. So you will say the percentage of insurance will be 121%, so that this 80 will become, when you put 121%, something around 110 plus, because 110 is the minimum requirement under the credit. Name of the first beneficiary may be substituted for the applicant, because now is the applicant of the LC, the applicant as far as the second beneficiary is concerned is the first beneficiary. Why? Because he is the buyer from the second beneficiary. Quantity can also be reduced, because if partial shipment is allowed, and if we are making a partial transfer, unless we reduce the quantity in the credit, there is no fun in reducing the amount. The first beneficiary has the right to substitute his own invoice and draft. Why? We have made a transfer for $80 out of an $100 LC. The second beneficiary will make shipment of the full quantity. Unit price you have reduced, you have increased. Unit price, the amount you have from 100 you have made 80. Unit price from 10 you have made 12, so that he will from 10 you have made 8. So he will claim $80. Second beneficiary. First beneficiary will substitute invoice and draft for $100 and 10 as a unit price, and a fresh draft for drawing all the $100 under the LC. So this invoice and draft is in excess of the amount of the invoice in the second beneficiary, but not in excess of the amount stipulated in the credit. So this is permissible. Transferring bank has the right to present the documents as received from second bene to the issuing bank. Transferring bank has the right to present the documents as received from the second beneficiary to the issuing bank when the first beneficiary on first demand fails to present its own invoice and draft, that is, fails to substitute the invoice and draft, or the first beneficiary on first demand fails to rectify the discrepancies created by their documents. If they don't present their own invoice and draft, or if they present their invoice and draft and that invoice and draft is making the documents discrepant, and if they don't rectify those discrepancies, then the transferring bank has the right to present the documents as received from second beni to the issuing bank, which means what? They will not be sending the invoice and draft of the first beni, but will be sending the invoice and draft of the second beni. Why? That was probably compliant, and because the first beni substituted some invoice and draft, it has become discrepant, and no payment is due because this is discrepant, payment is due because this is compliant. You will realize at least $80. Here you will lose all the $100. The first beneficiary may, in its request for transfer, indicate honor or negotiation is to be effected at the second beneficiary's place. This means what? When issuing an LC, the issuing bank says the LC is available by honor or negotiation with a particular bank at a particular place, available with State Bank of India, New Delhi. If the LCC is available with State Bank of India, New Delhi, and then if it has to be transferred, it can be transferred to Canara Bank, Chennai. So the first beneficiary may, in its request for transfer, indicate that honor or negotiation is to be effected at the second beneficiary's place. A different bank and different place can be there other than what is in the LC. Presentation of documents by or on behalf of second beneficiary must be made to the transferring bank. If a LC has been transferred under a transferable credit, the presentation by second beneficiary should be to the transferring bank. Presentation on behalf of second beneficiary should be to the transferring bank. Now let us have a look at assignment of proceeds, the final article under the UCP 600. Any proceeds which may be due or may become due to the beneficiary. Any proceeds which may be due or may become due to the beneficiary may be assigned, and this assignment will be in accordance with the provisions of the applicable law. It means what? UCP says, UCP doesn't say anything. It will be as per applicable law. What will be as per applicable law? Assignment of proceeds. Which proceeds? Proceeds which are due to beneficiary. When? We can't say. It may be due or may become due. So proceeds which may be due or may become due to the beneficiary may be assigned to any party as per the provisions of applicable law, local regulations. Credit is transferable or not has no implication on this ability to assign. The proceeds are assignable. Credit is transferable or not has no impact on the assignability of the credit proceeds. This talks about assignment of right to perform under the credit. No, only right to receive the proceeds. This article does not talk about right to perform. This article talks about right to receive the proceeds, if any, if it may become due or may be available to the beneficiary, whatever portion, and according to the provisions of the law. How it practically works is the beneficiary will give a notice of assignment. The nominated bank will send this notice of assignment to the party to whom it has been assigned, saying we have received a notice of assignment, we acknowledge it, and if any proceeds are due to beneficiary, we note to pay you your portion before paying the remaining portion to the beneficiary. This is how we do assignment. Thanks for watching this series on UCP DC. You have by now also become aware of the other series of sessions on other ICC rules like maybe Incoterm or URR or URC. We shall have another series of lectures on ISP, International Standard Banking Practices, and thereafter we shall turn our attention to the CDCS related approach to the ICC rules for examination of documents under international trade. Thanks for watching this video. We'll come back for another session on another